the important things in parole system. Presidential Decree 1257, participation of the prosecutor in the determination of the application for probation. Next is Presidential Decree 76, the period of punishment which is probationable is extended from 6 years and 1 day. Next, Presidential Decree 1990, the period of punishment which probationable is lowered again from 6 years and 1 day to 6 years or less. Next is EO 922, administrative into parole and probation administration. So next is the nature of information gathered. Strictly confidential is privilege. So this is privilege is a legal right that everyone has. It enables individuals and business to keep secret and sensitive information private. Under English law, there are rigorous guidelines for when privilege applies. Not all discussions with attorneys and other advisors are protected. Next is the nature of post-sentence investigation. It is the recommendatory in nature and addressed to the sound discretion of the trial court. So, no individual shall be placed on probation unless the probation officer has completed an investigation and the court has determined that the goals of justice and the best interest of the public as well as the defendants will be served. So, third is the effectivity of probation upon its issuance. When a probation order is issued, the court informs the offender of the implications and explains that if the offender fails to comply with any of the terms set forth in the order or commits another violation, he will be sentenced to serve the punishment imposed. Next is finality. The order of the court granting or denying probation shall be appealable. So, if no appeals is finalized after the reglementary deadline to appeal has expired, it becomes a reality. Both statutes acknowledge that such judgments are final in the sentence that dispose of, adjudicate, or resolve the parties' right in the matter. So next is petitioner. An accused or defendant files a formal petition for probation. So, it is the person on probation on trial in a job or a post to which they have recently been assigned. Next is absconding petitioner. A convicted defendant whose application for the probation has been given due course by the court but fails to report to the probation office or cannot be located within a reasonable period of time. So, this is a convicted offender who has been granted probation by the court but fails to report to the parole and probation office or cannot be traced within a reasonable time of frame. Moreover, I would like to explain what is parole. So, parole is the release of a prisoner on the promise of a good behavior, either temporarily for a specific purpose or totally before the end of term. Such commitment is known as the word of honor contained in the parole order. Next is what is the purpose of parole. Instead of returning to the community without supervision or support at the conclusion of their term, parole allows inmates to move from prison to the community in an organized, assisted, and monitored manner. And also, how is parole decided? The sort of punishment a criminal offender receives determine whether or not he or she is eligible for parole. Unless the court has set a minimum sentence length or given a determinate punishment, the offender is eligible for parole after serving 1/3 of the sentence. What is parole in legal terms? The conditional release of inmates before the end of their term is known as parole. Paroled inmates are overseen by a public authority known as parole officer. They may be sent back to jail. The laws governing parole differ from the one country to the next. Next is who qualifies for parole. inmate is serving an indefinite sentence with a potential length of more than 1 year. Next is who cannot be granted on parole. Those convicted to a 1 year or shorter term of imprisonment, a direct punishment, or a jail sentence without a minimum period of incarceration. And that's all. Thank you and God bless you. Stay safe.